A very good estate planning question is, what happens if I die without a will? Now, if you don't have a will or other estate planning documents, state law actually decides where your property goes. Now, that may or may not correspond to your actual wishes. For example, if you leave behind a spouse and children, your spouse will get a little more than half of your assets and your children will get the other half. But what if you wanted to leave all of your assets to your spouse and only then to your children? Well, you should have written a will, because the results are sometimes unexpected and sometimes people do not want to leave their children equal amounts or anything. For that purpose, you need a will or different estate planning documents such as trusts. Certain people make verbal promises during their lifetime to some of their children. I will leave you the house, I will leave you this, I will leave you that. But guess what? Those promises are unenforceable unless they are written in a will that is properly signed, witnessed, and notarized. So what happens if a person dies without that will? That promise goes outside the window. Same thing if you want to give your children somewhat unequal shares. If you've already provided for one of them and want to leave them less money and assets than the other one, you need to specify that in a will. Otherwise, it will be distributed equally according to state law and maybe not the way you want. That is a good reason to speak with an attorney and to prepare and sign a will and possibly other estate planning documents that fit your goals and needs.